Welcome to Inside the Gavel Lessons from the Bench. I'm your host, Sarah, and today we're honored to have with us retired Judge William Hamilton. With over 30 years on the bench, Judge Hamilton is here to share his deep experience and teach us some pivotal courtroom phrases. We will explore terms such as what is your case, overruled, court is adjourned, strongest case, you may proceed, recess the case, short recess, and rule in favor of. Judge Hamilton, thank you for joining us.
Thank you, Sarah. It's a pleasure to be here and share insights from my years in the courtroom. Let's begin by discussing these common phrases that not only structure courtroom proceedings, but also reflect the discipline and clarity required in judicial practice.
That sounds great. Let's start with the phrase, what is your case? Could you explain its significance?
Certainly, what is your case is a question I would often ask counsel to prompt them to give a concise summary of their argument. It demands clarity and focus, a brief, compelling overview of the legal and factual issues at hand. For example, in one memorable session, I asked, "Counsel, what is your case?" And the response was a succinct, well-organized summary that immediately set the tone for the proceedings. This phrase reinforces the need for precise argumentation.
I see. The emphasis on clarity is vital. Now, another phrase that comes up frequently is overruled. How is that used?
Overruled is an authoritative command used when an objection by counsel is rejected. During hearings, if a lawyer objects on a point that doesn't conform to legal rules or relevance, I would declare overruled to allow the proceedings to continue unhindered. I recall one instance where, during a heated exchange, I had to firmly state overruled to keep the discussion on track. This term is essential for maintaining order and ensuring that only admissible evidence and arguments influence the court's decision.
That makes sense. Another phrase you often use is court is adjourned. What does that indicate?
Court is adjourned signals the formal end of a court session or hearing. It means that the work for that day has concluded and everyone should disperse in an orderly manner. I've used it after delivering final rulings or once all the necessary arguments have been presented. Think of it as closing the chapter on that specific session, a clear directive to conclude the proceedings until the next scheduled date.
Excellent. Now moving to the term strongest case. Could you elaborate on that?
The phrase strongest case refers to the argument or evidence that is most persuasive and legally sound. In my tenure, I examined countless cases, and I always stressed that the case with the clearest facts and the most compelling legal reasoning was the one that ultimately prevailed. It's a reminder to all counsel that well-prepared, clearly presented evidence makes all the difference.
And how about when you say you may proceed? What context does that have?
You may proceed is a directive I use to signal that a lawyer can continue with their presentation or question a witness. This phrase acts as an encouragement to move forward after a brief pause, ensuring that the courtroom momentum is maintained. It's both a permission and an affirmation of the lawyer's preparedness to further their argument.
That's very informative. Another phrase we must discuss is recess the case. What does that entail?
Recess the case is used when I decide to take a temporary pause in the proceedings. This could be for several reasons: to allow the parties a moment to confer, to review additional materials, or simply to give everyone a short break. I often specify the duration as in short recess to indicate that the interruption will be brief and the court will resume shortly. This is especially useful in complex cases where a momentary pause can clarify confusion and help streamline the next steps.
That really highlights the importance of timing and structure in a trial. Lastly, could you explain the term rule in favor of?
Rule in favor of is the conclusive phrase indicating a judicial decision that supports one party's claims over the others. It's the final judgment where, after weighing all evidence and arguments, the court decides which side has met the legal burden of proof. When I say I rule in favor of the defendant, it means that based on the merits of the case as presented, the defendant's position is legally upheld.
Thank you, Judge Hamilton. I'm sure our listeners appreciate the clear explanations and personal anecdotes that help demystify these courtroom phrases. Could you share one final piece of advice for those interested in law or those preparing for a courtroom observation?
My advice is simple: always focus on clarity and precision. Whether you are a lawyer, a student, or simply an observer, understanding and using these terms accurately is crucial They are the building blocks of effective legal argumentation and judicial reasoning. Familiarize yourself with these phrases, listen to real court proceedings, and always remember that every word matters.
That's excellent advice. To recap, today we covered essential courtroom terms. What is your case? Overruled. Court is adjourned. Strongest case. You may proceed. Recess the case. Short recess. And rule in favor of. You've provided invaluable insight, Judge Hamilton, that will surely benefit law students and courtroom enthusiasts alike.
Thank you, Sarah. It's been a pleasure discussing these terms with you. My hope is that our conversation today inspires future legal professionals to value clear communication and respect the power of every judicial word.
That wraps up today's session of Inside the Gavel, Lessons from the Bench. Thank you to our listeners for tuning in. We encourage you to review today's terms, reflect on the insights shared by Judge Hamilton, and apply these lessons as you watch courtroom proceedings or consider a career in law.